Barely 2 months after President Muhammadu Buhari passed into law the Petroleum Industry Act, the Senate received a request from the president to amend the PIA. The president explained that the appointment of 2 non-executive members as provided by the Act to the board of the Nigerian Midstream and Downstream Petroleum Regulatory Authority and Upstream Regulatory Commission, URC, does not reflect balanced geopolitical representation. He therefore requested amendment to Section 11 and Subsection 2B and Section 34, Subsections 2B, which provides for administrative structure of the PIA 2021 to increase the number of non-executive members for 2 to 6 boards of the NPRA and URC. Well, joining me to look at the developments following the passing into law of the PIA is a partner, Cantlep, and director, ASPEN Energy, Mr. Israel Aye. Good afternoon, Mr. Aye. It's good to see you today.
Good afternoon, Tolu. Pleasure to be here.
Yes, first, we are already having amendments, or we're already asking, the president is proposing for some amendments. Some say that this could send negative signals to investors. Just 2-3 months and we're already having issues. I don't know if you also think along that line. A lot of expectations with regards to the PIA. But with all of this rejigging and all of that, don't you think it could affect investors' confidence?
Okay, so we can unpack that very carefully in the sense that, I mean, if there's a positive spin, it is that we're demonstrating clearly, at least within this regime, some measure of agility and flexibility with respect to lawmaking. One of the major criticisms of our entire legislative process is that it tends to move generally too slowly, unless when perhaps there is a vested interest in driving the agenda. That's probably true about many other clients, apart from Nigeria. So that, if you spin it independently, is probably a positive message to take away from this. However, for a piece of legislation that has just been made, going very quickly to fix a part of it for the reasons, especially for the reasons we're doing, then leaves a lot of worry. And what it means perhaps is that the transition, or perhaps the wait, is not entirely ended. Remember that when the law was passed, what we said was that the cloud of uncertainty that sat over the industry has been dispelled, and that investors can begin to think of about returning to get whatever value they can from here. But if we're going very quickly to amend one thing, and we probably will need to return to amend another thing, then the tendency is for people to say, well, let's wait and see. Let's see when the thing crystallizes. Because what is to say that the fiscal provisions will not be amended tomorrow, or something else that will drive investment? So that's probably one way to look at it.
Okay, we have this steering committee that has 12 months to do a lot of work, and one of it is to say that the NNPC will be incorporated, which is as if the process has already started. Take us through how this is going to happen and what we should expect. Even the NNPC GMD was out to say that they're considering an IPO in the next 3 years.
Okay, I mean, the steering committee and its mandate, vis-a-vis some of the timelines that have been prescribed in the law, is probably a little bit of windowing and adjustments are going to be seen. Some people had mentioned indeed that the timeline that was prescribed to the steering committee was a bit confusing. Were they supposed to drive transition within a 12-month period? Were they supposed to study the transition and come back in 12 months, which is when transition begins? That was a bit confusing, because if you remember, the law itself does prescribe some timelines for things to happen. 6 months within which to incorporate an entity. I mean, how long does it take to incorporate an entity? Normally, it doesn't take that long. So perhaps incorporating it is not the issue. And then a certain time to transfer assets, 18 to about 24 months to transfer assets, and the likes of it. So hopefully what we're seeing is that we're getting the education of the road. As the tire meets the road, we're beginning to see that adjustment happen. The transition is on. Thank goodness for that. the regulators have been set up. The NNPC, as it is presently constituted, has been mandated to drive the incorporation of the new NNPC. Indeed, a board has been named to assume the reins once that entity is set up. So we're seeing the transition in full steam. Your last question was whether or not NNPC can, in fact, IPO. Now, you can do either a national IPO or indeed an international IPO. At the end of the day, it is return on investment that is going to drive the offtake in the market. And that is something that is left to be seen. And one of the things that will drive investor confidence, whether it's local or international, will be the governance. And my honest view is that we miss an opportunity to establish a strong governance, a strong board for the national oil companies, similar to what our peers are doing around the world. And I have cited, I believe, in another talk with one of your colleagues yesterday, that we do not need to look far. Let's just look at Saudi Aramco and see how they've set up their board. Typically, the way you name your board, you set it up, is indicative of what your orientation is going to be. And I think that we need to do better in that space. I would have thought perhaps that was what we were going to go back to the National Assembly to try and correct. As a matter of fact, my attitude is we shouldn't even hardwire the nomination of the board in a law. As a matter, the majority shareholders should be able to name a board. In this case, it is the federal government on behalf of the federation, and that should be able to name an internationally competitive board.
Staying with NNPC, I want to say it the way I saw it while researching ahead of this interview. Some say, or some experts have come out to say, that incorporating NNPC will end politics and years of corruption in the corporation. Do you see that also happening, Mr. A?
Well, the first thing that we understand is that NNPC Limited will no longer receive money, from the Federation account. And what that means is that it will be driven, hopefully, by economics rather than politics, which is what I find particularly dismaying about the amendments that have now been sought to be made with respect to the regulators. I do not see how geopolitical representation is a good basis for populating that board. Again, too many of our decisions are driven by politics rather than economic considerations. So, indeed, would the incorporating an NNPC Limited diminish political proclivities within the decision-making framework? That is left to be seen. But I would not like to imagine that if there is no easy cash, no free money, if there is no appropriation of funds from Federation account, hopefully people would make commercial and economic decisions for that. So that's probably where that confidence comes from. But again, if you extrapolate this to maybe one of the best one of the best clients of public institutions is China. And they have state-owned entities that are sufficient as any privately run entity around the world. And what we have learned from them is that they seed the company with the initial seed, and they allow you to swim or sink, to float or not. So as long as we're not doing constant bailouts and those kinds of things, yes, hopefully politics will decline, sound and sensible economic drivers will ascend.
Also, some say that when President Buhari demanded an amendment, the issue of the host community and, of course, frontier exploration was not touched in this. Do you have any reaction to that?
Well, again, this piece of legislation has just been put in place, and while on the one hand, I have expressed the view that going back to seek the amendment of a portion or provision of the law potentially signals our ability to be flexible and nimble and agile we also don't want to come across as indecisive and responding in a knee-jerk fashion. So I'm hoping that if we have to go back at all, then let us sit down, go over that piece of legislation, do a one-round comb, and return with it. Otherwise, let us allow the law to run and be tested before we start to tweak and turn things around. Then we would have managed, if we went about it that way, we would have managed to snatch defeat out of the jaws of victory.
And now, Mr. Ye, one thing that also comes to my mind, and we've not talked about it for some time, is the issue of subsidy. Is it because government and labor is still talking, or are we just putting that on one side? Because I remember talking to an analyst, and I said some governments consider themselves being unpopular when they come up with policies like that. When we hear subsidy removal on PMS, and we're also expecting subsidy removal on electricity coming very soon. So what do you make of all of this, and as it regards to PIA?
Okay, the legal framework for electricity, the legal framework for the governance and management of electricity supply in Nigeria is different, as you're aware, from that of the petroleum industry generally. So you have to take them separately. If you're talking about the subsidy of PMS, again, there are typically two issues, maybe three. There is policy, there is law, there is commercial. And the three will need to jive in order for you to be able to get any specific outcomes. Under the old order, it seemed as if all of them sort of aligned, quite frankly, along a particular line. There was a statutory basis, i.e. a legal basis for price control. It was the Petroleum Act, it was the Price Control Act. Those ones provided to the President the authority and the power, as a matter of fact, the duty to be able to set prices and to control prices of petroleum products. Because those were considered strategic utilities in times past. It has become very untenable for us to be able to do so. So that's the law. The policy, of course, is what I've explained as well. The commercial, as a matter of fact, is then the interaction between demand and supply, and which is what drives everything at the end of the day. So it does not matter what the law is or what the policy is, as long as you have not interfered with supply in order to increase it, then you would either have to allow price to be set at the level that those who bring in the products can, or you will have to intervene in the way that you do by way of subsidy. Unfortunately, that has become too expensive for us to do and not as productive as many people think it is. So I'm hoping that somewhere we'll keep windowing this until we get the right outcome. And what do I mean by that? Let us see how many more of this we can license. Let us see how many more of this we can incentivize to come on stream. Let us see how we can further tweak the fiscal framework in order to be able to just bring more and more refineries on stream to be able to influence, the supply of the product. That way, your policy and law will work better to deliver the outcome that we want, which is a market-driven situation that is not a burden on public funds and wasteful, as we have tended to see in the last few years.
Before I let you go, Mr. Israel, at this time where we have issues with the dollar and of course the naira, we know what is happening. About 572 naira at the parallel market. Well, at the I&E window, it's still about 415, but that's not really my question. I'm looking at refining, because we still keep bringing in these products. NNPC is a sole importer. We are all aware of that. But what's the provision for refining also maybe in the PIA? And don't forget that $1.5 billion is still on the PA Port Harcourt refinery, which the NNPC GMD says very soon a portion or a part of it would have been fixed. So we just have to move on to other segments of it. But what do you make of all of this with regards to our refining process?
Okay, so this is a theme that runs through a number of things in our lives generally. I mean, if you remember telecoms in times past, that was locked in a state-owned monopoly that was grossly inefficient, and as a result, not a lot of people had access to telephony services. I mean, in total, we had just about 400,000 lines. Potentially 50% of those were tied up in entangled wires across the country, and nobody could quite access them, and it was a rare commodity. Take power again as an example. You asked me about power earlier on. I always remind people that the first power plant in Nigeria, that is the Jora power plant, was built 15 years after power was introduced to the UK. But you definitely can't look at the UK today and say that we're at par in terms of installed capacities. The UK has over 100 gigabytes of installed power, and they're still providing for future use even before populations have arrived in that area. What's the difference? The difference is that we locked us in an inefficient state-owned monopoly, and which led to gross underinvestment across many years. As a result, we simply did not have the capacity to be able to produce. Similar to what we did with telecom, we opened up that space, supply went up, and everybody has a phone today. If we do the same thing with power, what we've done is that we've constrained, especially, and I've had people debate this with me, but we've constrained power at the end of, at the offtake point, where we're still setting the price, and as a result, not a lot of people are willing to come in and make the investment to be able to recover the investment and make money in the process. It's the same thing with refining. One of the things that has constrained refineries generally is the fact that pump prices are controlled. I mean, investors are not likely to put their money in a sector where they cannot recover prices at a cost-reflective. They cannot recover cost-reflective prices. Hopefully, the PIA has changed the basis for that to happen. What you'd like to see in addition to that now would be the supporting sort of policy framework, and I'd like to see very specific. If you take the Dangote refinery, for example, and it's probably oversimplifying it, but one of the things that enabled that project is the fact that it is set within a free trade zone. So in other words, when the Dangote refinery comes on stream, he can sell his product at a cost-reflective price because it is an export zone. And it is then the problem of the government, whether they want to subsidize it or just allow it to go into the market at a cost-reflective rate. But not every licensed person may be able to have that privilege. So what do we need to do? We need to create those sort of batteries of incentives to influence supply. And that is only when we can deal with this. But as long as we lock in any sector in these inefficient monopolies, then we're just wasting our time. At the end of the day, it does not matter what you have in the books or what the law says. If the product that is coming in is far less than what people require, then you have a problem at that level. I mean, a whole lot of things even happen. Then you create a subsidy that does not go to the people you need, and then the products make their way to neighboring countries where people can earn an arbitrage, and it creates all kinds of dysfunctions within the system. I would refrain from commenting about the NNPC. I mean, again, for me, at the NNPC refineries, it is a capacity issue. When was the last time anybody talked about NITEL as a company? I remember there was a time when NITEL was central, front, center, and back of every every conversation in the telecoms area. When was the last time we talked about NITEL? Similarly, if we can open up that space and create more players, or invite more players and create greater supply, honestly, turnaround maintenance and the likes of it will be a thing of the past.
It's always interesting talking to you, partner Campdale. That's a Canlip and director ASPEN Energy. Yeah, I got that correctly. Mr. Israel Aye. Thank you very much for your time and enjoy your weekend.
Thank you, too. Have a great weekend. Bon weekend. Thanks.
All right, then.